Hello, everyone. My name is Sophia Pintar. I am a law clerk here at Lyles Parker. Thank you so much for joining us for this new webinar series with Home Care Association of Louisiana. Today's webinar is entitled Practical Advice for Strengthening Your In-Home Health and Hospice Compliance Program. Our presenters for today are Regina Morano and Michael Cook, who will tell you a little bit more about themselves in a moment. And just a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box while we will address as many as possible at the end of the presentation. Without further ado, I present your speakers, Regina, Michael Cook, and Regina Morano.
Good afternoon, everybody. First of all, I want to thank each of you for taking your lunch hour to join Regina and me at our presentation today. My name is Michael Cook, and I'm a partner and co-chair of the healthcare group at Lyles Parker. I've been practicing healthcare law and representing healthcare-related clients in private practice since 1981 in all kinds of regulatory enforcement, compliance, investigation, business, and health policy matters. And before that, I represented the federal regulators of Medicare and Medicaid programs as an attorney with the General Counsel's Office at the United States Department of Health and Human Services for over 7 years. And during that time, also served on detail as a special United States attorney in the Northern District of Illinois, the Chicago area. Until recently, I served on the board that oversees and advises Virginia's Medicaid program. The last 3 years as the chair have advised a number of state and national political campaigns on healthcare issues, including 3 presidential campaigns, and I'm a fellow of the American Health Law Association. I'm very fortunate to be joined by my colleague and co-presenter, Regina Morano. Regina, why don't you take over?
Thank you, Michael. And thanks to our host today for including us and giving us an opportunity to speak today on practical advice for in-home health and hospice compliance. As Michael said, my name is Regina Morano, also an attorney with Lyles Parker. I've been practicing exclusively health law now for almost 28 years in both the private and the public sectors. I have really experience in all aspects of healthcare. I have worked on the provider side, including skilled nursing, home health, hospitals, academic medical centers, laboratories, as well as leading payer organizations such as HCLA, Blue Cross Blue Shield in New York, which is the largest not-for-profit Blue Cross in that state. I currently focus on compliance matters and regulatory matters involving hospitals, physician practices, lab. I've focused on interventional pain in recent years, spent a number of years as special counsel to the chairman of Workers' Compensation Board in New York, have experience with implementing strategic implementation of corporate integrity agreements, and continue to advise and assist healthcare providers in virtually every aspect of healthcare. So along with Michael, I'm so happy to be here today. I know we have a lot of material we want to go through and a lot of information we want to share with you. So I think we'll just go ahead and get started. If we could skip to the next slide. We do want to make it clear that this is not legal advice. We're providing today information, and that anything we say or cover with you today doesn't create an attorney-client relationship. And if you do need legal advice on any of these matters, we do urge you to seek out legal representation in your area. Moving on to the agenda. Just to give you an outline on the next slide regarding what we're going to cover. So we'll start with the enforcement background, a couple of points we want to convey to set the stage for what the enforcement background looks like for home health and hospice providers. We're going to talk about compliance programs in general. A lot of that is based on the OIG guidance documents. We're going to walk through and point you in that direction. Important OIG guidance documents that really create the structure for compliance in your practice areas. We're going to talk about audits, some of the key audits that we've seen, focus areas that we've seen around CMS and other payer audits in recent years. The importance of screening for excluded individuals and some practical advice around that. Also some practical advice around subpoenas and search warrants and investigations and how to handle those and how to be prepared for those. Michael's going to share in particular some new information around safe harbors on the anti-kickback side, and then we'll wrap up with some general tips for best practices. Moving on to this next slide. So we do want to sort of set the stage by pointing out that, you know, the whole rationale or the whole impetus really for the increased scrutiny that we see on the healthcare side has to do, it's tied directly to the increase in spending. The Medicare program in particular and its offshoots in Medicaid and Veterans Health and Indian Health Service and the other sort of smaller federal healthcare programs, the spending has just increased exponentially in recent years, in the past decade or two. And, you know, when you have services such as home health and when you have services such as home health and hospice, where the services are not taking place in a hospital or a physician's office, where there's sort of a close eye on the patient interaction and the referral sources, there is always going to be increased scrutiny. And our second point on that slide, I know we skipped past it, but we did want to just you know, make it clear, if you're not already experiencing this in your own field, that, you know, the statutory and regulatory requirements are just enormous. They overlap, they're very dense, they're always changing, and failure to comply with these regulations can expose you to not only civil monetary penalties, but ultimately for criminal behavior, there would be criminal penalties. So in terms of the 30-year look back on the next slide, we wanted to point out a couple of things. You know, there have been a significant amount of criminal prosecution in the last decade or so. And what's really interesting is that the federal criminal prosecutions, where those have been concentrated, they've been concentrated on domestic, meaning within the United States. They've been concentrated on private entities, and they've been concentrated on smaller entities. And this is obviously, you know, by the numbers, this looks to be where the risk areas are, smaller entities in the private sector and within the sort of the four walls of the United States. So an overwhelming majority of these folks who have been prosecuted, one of the things they have in common, unfortunately, is they did not have compliance programs. And it just really underscores not just the need for a compliance program, but the effect that a compliance program can have on your culture and your ability to perform and bill and behave correctly. And then here's another really interesting fact here. Of the 5,000 organizations that have been criminally prosecuted, only 11 of those have been able to get what's called a sentence reduction by essentially putting the compliance program in place and operating it. So to me, that says the rest of those organizations either didn't have a compliance program or they had one on paper, but they didn't run it. So it just really underscores all of these sort of facts here on this particular slide really do underscore the importance of having a compliance program, because the government looks for it and because they work. And there is also that last bullet there, important to point out, there is also a huge focus, ever increasing focus on accountability for individuals who are involved in criminal conduct. And the government has gotten very serious about that, particularly in the last 2 or 3 years. There have been some pronouncements from the Department of Justice over the last couple of years indicating that it's not going to be enough anymore for companies to pay huge fines and walk away from misconduct. Individuals are being pursued and individuals are being prosecuted. So accountability is key. And with that as a little bit of background, Michael's going to talk with us on the next slide about investigation and enforcement efforts.
Yeah, fast forward to today. The government has set up interagency teams of investigators and prosecutors from the Department of Justice and Health and Human Services Office of OIG to investigate and prosecute serious healthcare fraud, among other areas. And these strike force teams are located in 9 areas designated on the map, covering a variety of regions, including what is referred to as the Gulf Coast Task Force in New Orleans, Baton Rouge, and Gulfport, Louisiana. Given the mission of the strike force operations, these are the areas in location that are considered hotspots for healthcare fraud, and providers in these areas, including home health agencies and hospices, are going to receive even greater scrutiny than in other areas of the country. And that's in an industry that is already receiving scrutiny from enforcement agencies. Gio, the next slide, if we could. The next slide also reflects both the focus of the government on corporate crime, but also the focus on going after those individuals, especially senior executives, who the government finds to be responsible for the alleged misdeeds, and the importance of the various compliance program, of the vigorous compliance program, in not only avoiding violations, but also mitigating the consequences when something goes wrong. And Regina pointed out the fact that under what we call the sentencing guidelines, only 11 of the 5,000 prosecutions at this point received corporate credit under the sentencing guidelines. However, as Regina and any of us who have been involved in representing clients in investigations can tell you, the discussion at the Office of Inspector General and the Department of Justice is very different when you have an active and vigorous and effective corporate compliance program versus those entities that either don't have what the regulators consider to be an effective compliance program, or where they have none at all. This slide is a quote from the September 2022 update to a guidance issued in late 2021 by the current Deputy Attorney General, Lisa Monaco, to emphasize that in addition to penalizing the corporation in criminal corporate matters, the government's also going to be looking to hold accountable individuals, including executives who may have been responsible or profited from the crime. You can read it at your leisure, either now or you can. We're happy to send a copy of the PowerPoint to you if you ask us. Send us an email. It also shows a recent emphasis by the Department of Justice to expect corporate compliance programs to focus on how compensation is treated under the compliance program. For example, financial penalties for non-compliance and/or rewards for strong compliance. And Regina and I are going to talk about the stress that the government's putting on that these days. Gio, next slide, if you could. This slide 9 is a quote from the Department of Justice Manual on the Principles of Federal Prosecution of Business Organizations. The DOJ Manual is a statement of the department's policy that all U.S. attorneys follow, and as the italicized language indicates, the state of a corporation's compliance program is going to have an important impact on whether and how the government enters into either a plea agreement, a deferred prosecution agreement, or a non-prosecution agreement to resolve a criminal matter, as opposed to a vigorous prosecution. As I mentioned before, we always tell our clients and audiences in our webinars, if something goes wrong in the organization, the discussions with the Department of Justice and OIG are dramatically different if you can show a strong and active compliance program and argue that you had an act by a rogue individual who deviated from an otherwise strong compliant organization with a culture of compliance, as opposed to an organization that may have turned a blind eye to compliance by its failure to have such a program. Gio, next slide, if you could. The italicized language on this slide just reiterates the importance of a strong and active compliance program by stating as one of the factors to be considered by the DOJ in determining whether to prosecute a corporate target. Basically, the adequacy and effectiveness of the corporation's compliance program at the time of the offense, as well as at the time of the charging decision. Next slide, Gio. Finally, in this vein, this next slide from the Department of Justice Manual cites several key factors, including the importance of a compliance program as part of the corporate culture. And you'll hear that in the talk of having a culture of compliance in just about any lecture that you go to in this area, that the program cannot be just a paper program, and that the recent emphasis on incentivizing employee and executive compliance through compensation structures, such as an executive clawback where violations occur. And Regina, as a corporate compliance officer, do you want to jump in briefly about the new focus on compliance in this area?
Yeah, I mean, it's new. Everything old is new again. There is recently some guidance that's come out from the Department of Justice, and they're very heavily pushing clawbacks. For example, executive bonuses that are tied to programs or tied to behavior that resulted in financial windfalls to the company, but unfortunately, at the same time, were financial success that was tied to improper or unacceptable or unlawful behavior. So not only is the government pushing for individual accountability, they're saying put your money where your mouth is, and they are asking companies to claw back or take back compensation, particularly bonuses that are tied to programs or activities that were based on unlawful behavior or unlawful actions by the company or individuals.
Yeah, Regina, do you want to discuss this slide as well?
I sure do. So Michael's talking about, the importance of having a compliance program and how a real compliance program, a well-structured and functioning program can assist you in the event that you run into trouble with enforcement or investigation by the government. And so the question then is, well, what is an effective program? What does the government believe is a sufficient or effective program on the compliance side? And so these are the 7 elements that the government has identified, and I'm going to just walk you through those from a high level. I know we're both going to get into some detail in a few moments, how these come into play on the hospice side and how they come into play in particular on the home health side. But the 7 basic elements that you should know and that you should make sure your compliance program is structured around include, first of all, the whole basis of your program would be written standards of conduct. So this means adopting and operating under compliance policies and procedures, starting with a code of conduct that governs how your workforce operates, how your workforce interacts with itself, with each other, with your healthcare partners out in the field, with patients. So there should be a good, solid code of conduct, a very comprehensive code of conduct, and a variety of policies and procedures that govern, for example, that first of all, set up, number 2, a compliance officer and a functioning compliance committee that includes representatives of management. The compliance policies and procedures should set up an effective compliance education and training program. At a bare minimum, there should be onboard compliance training, and there should be annual compliance training for your entire workforce. The government also wants to see effective lines of communication, which means they want to see that there is a path to get to your compliance officer and to get to your management team with compliance questions, concerns, reports of potential violations. So everyone at this point really does need to have a hotline, preferably an anonymous hotline that people can call either by phone or reach it online and anonymously choose to report potential violations and compliance concerns. There have to be well-publicized disciplinary guidelines. So, for example, there need to be HR policies that talk about the fact that the workforce is required to comply with compliance standards. So, and those should be well-publicized. That should all be in your handbook. That should be in your onboarding materials as well. There should also be an internal monitoring and auditing. So you really need to have an annual work plan that's based on risk areas. We'll talk about some of those risk areas today, but there are risk areas, that are unique to your own organization, maybe based on location or staff size or the particular providers that you're partnering with. You really need to have routine audits going on all year long, and you need to be monitoring and auditing, particularly around referrals, around integrity of claims, around reconciliation of money coming from the government, et cetera. And then you need to have a policy, and you need to have a culture that sets you up to not only identify potential offenses, but to develop and implement corrective action. So if you have all of that, you have policies lining all of that up and setting that all up in structure, and all of that is live in your environment, you have a strong basis, a strongly based compliance program. And I know we're going to separate home health from hospice. We're going to start with home health and talk about that model guidance and some of these risk areas, et cetera. Michael is going to take that piece of it now, and I'll be back in a little while.
All right, let's talk now a little bit about the model guidances that are out there. During the late 1990s, the OIG published several model compliance program guidances in the Federal Register, including, as Regina mentioned, separate guidances for home health agencies and hospices. Given the period of time that has passed since these original guidances, and for example, up here you can see that for home health it was in August of 1998. OIG's recently announced that it's going to be developing updated guidances, both general and provider specific in the future, that it's going to place on its website as opposed to publishing in the Federal Register as they've done in the past. However, the older guidances contained a section on risk factors, which, while somewhat dated, still are valuable to review since they show activities that the government has in the past and still considers highly problematic. And these next 4 slides identify the risk areas for home health agencies. They're on these slides as a reference, and I'm not going to go over each one of them, nor is Regina, but rather we're going to point out and discuss a few. First on this slide, an obvious risk factor is both the medical necessity of services and the need to adequately document that fact. Also, as we'll discuss shortly, your relationships with physicians is still an area of focus, especially with your medical directors. Next slide, if we could, Gio. I just want to point out here something that I'm sure all of your staff and you understand, but there is generally nothing wrong with amending a note to correct or add something, but it's absolutely critical that you make sure that you indicate in that note the date on which the amendment or addition is added and do not otherwise alter the record. Also, it's critical that you properly manage and oversee subcontracted providers, especially in your billing, marketing, and staffing services that you contract out. We're going to be discussing marketing in greater depth later in the presentation, but these services were part of a list of questions that a UPIC recently sent out to certain agencies, so they are still a focus of government scrutiny. And also, as we're going to discuss later in the presentation, you can be held responsible for a contractor's use of an excluded individual with respect to your agency. Next slide, Gio, if you could. I'd especially point out several of these items here. Compensation programs that offer incentives for a number of visits performed and revenue generated. And Regina talked about the focus of just the reverse in your compensation packages that DOJ and the OIG are expecting. Also, as we mentioned earlier, DOJ is really focused on these programs to encourage compliance, not non-compliance, when a company is under investigation. Another one of these is duplication of services provided by assisted living facilities. A number of home health agencies, as you're all aware, contract for space in an assisted living facility as well. And we'll discuss those in just a second in a little more detail. Also, the failure to return known overpayments made by government programs. There are now specific regulations that discuss how to handle potential overpayments, but the key is that you're required to return overpayments when you become aware of when you become aware of them, or they become a false claim, and that's even if the government hasn't identified them as of yet. It's your responsibility once you know or suspect of an overpayment. Next slide, Gio, if you would. We've discussed the alteration of documentation earlier, and we're going to discuss the employment of excluded individuals later in this presentation, but they are both clear risk factors that need to be part of your compliance program. Next slide, Gio. We're going to discuss marketing activities later in the presentation, but obviously you need to avoid improper patient solicitation, including gifts or also pushing unnecessary services. I do want to note that while gifts to patients are problematic, where you have a value-based arrangement under the new safe harbors that we're going to discuss elsewhere, there may be certain circumstances where the participants in the value-based arrangement can provide patients with health-related products such as wearable monitors, but you should do so only after reviewing the arrangements with knowledgeable legal counsel and your compliance officer. With respect to services provided to patients in assisted living facilities, I've had several occasions over the years in advising clients either in the provision of these services when they're looking at acquisitions, or in one case, in an investigation by the Department of Justice on the issue. There are many instances, as I mentioned, where home health agencies, rehab agencies, and physicians will lease space in assisted living facilities to be able to provide services to the assisted living facilities residents. We're done, they can certainly provide, and a lot of assisted living facilities view these as really helpful to their residents because of the proximity and the ability to avoid traveling to these services. However, where they're done, you need to make sure that you're paying no more than the fair market value for the space. It may be a monthly charge, at the monthly charge for the room, but not including any services that the assisted living facility might provide. A better way is to check on square footage in comparable space in the area, not including any markup for proximity or access to patients, and make sure that you document and save the documentation to support the lease. And obviously the lease ought to be documented on paper. And you want to meet all the elements of the space rental safe harbor as revised. And I know I was involved in a very large joint venture acquisition, and that was a huge issue when we were doing our due diligence in one of the assisted living facilities. Also, I remember way long ago, a real assisted living facilities for one company were under real estate, and I got a call from counsel, and when I finished explaining the process to him, he said, well, I guess that means I have to demand that the physician pay me less rent. So you've got to be careful in those areas. And there was also an issue of duplication of services that actually generated an investigation that I was part of years ago. Back again in the, I believe it was in the late 90s, there was something known as the Hoyer memo, which was a memo put out by Tom Hoyer, developed by Tom Hoyer at HHS, and was a little bit confusing, but basically you shouldn't be providing services in a facility that are otherwise covered under the resident contract or required to be provided by the assisted living facility under state law. The ALF can contract with a home health agency for that particular service and pay you directly, but it should not be billed to the public programs. I was actually involved in an investigation years ago by Justice that was generated by an email from the chief compliance officer of the home health company that basically said they were in deep trouble. In fact, I think it said deep doo-doo. In fact, it turned out that the company was actually doing it right, and the company was obviously able to avoid prosecution, but the investigation cost several $100,000 in legal fees to prove that they were doing it right. So basically, there were two lessons there. One, make sure you're not duplicating services, and two, be real careful about the emails that you send out, especially since you may be under subpoena for emails at some point in time. Also, one of the questions on the questionnaire sent out recently by the UPIC that I discussed earlier involves the home health agency's relationships with assisted living facilities. So it's still an area of inquiry. And finally, hospitals need to be careful with steerage to home health agencies that they own. Can we go to the next page, Gio? We've discussed the topic, the top risk factor with respect to assisted living facilities, but it may also, a second fact on there is that it may be useful for legal counsel to review all of an agency's contracts. Now, obviously, this is going to depend on the size of the agency or company, whether you've got in-house counsel and such, but it's a good idea, and certainly your major contracts ought to be looked at by legal counsel. Another key point, again, is that contractors need to be aware of and comply with the agency's your compliance program, and you should attempt to place in your contracts with subcontractors a requirement that they comply with your programs, if at all possible. And it's especially important with respect to independent contractors responsible for marketing activities that Regina is going to discuss in greater detail later in the program. And again, as we're going to discuss when we get to the prohibition on excluded individuals, providers can be held responsible for the use of such individuals by their contractors. Gio, the next one. Just the first bullet. The first bullet focuses on the importance of training, as Regina can tell you during this, and as she did, and when she went over the seven elements, training of your employees and corporate officers is critical on a yearly basis. And again, training is one of the issues raised in the questionnaire that the UPIC sent out. Also, as you know, agencies are expected to conduct audits in certain areas in their compliance programs. Gio, the next. Regina is now going to discuss the next several slides on hospice compliance. However, as a seasoned compliance officer for training and preparing audit plans, do you want to comment briefly on that, on those, Regina?
On preparing the compliance plans, Michael?
Yeah.
I think everything you outlined, I would just underscore that, but I would add that one key factor when you're developing your compliance plan, you do that based on a risk assessment. So ideally, you're creating your compliance plan at the end of a calendar year to be executed in the following year. But you have to back that up a little bit. Maybe in the beginning of the third quarter, for example, you would do a risk assessment to figure out where your top risk areas are, and then build your plan around those risks. So,
Regina?
okay. Yes. Can you hear me okay?
Yes, I think the next slides are yours.
Yes, this whole section is I'm going to cover for you. As Michael said, the OIG, Office of Inspector General, came out with some compliance model program guidance for really all types of providers in the mid to late 90s over the course of many years. And so these model compliance programs have a very common thread. The basic structure of them is very similar, but each of these provider areas obviously have their own very unique risks. So I'm going to talk for several slides around some of the risk areas that are unique to hospice. As Michael went into detail regarding home health, I'm going to speak about hospice. And I'm going to do that by highlighting a few of the bullets on each of the slides. I'll leave it to you to look at all of the bullets on these slides and all of the areas that we've noted, but I do want to highlight a few. So starting there on slide number 20, lack of informed consent is a fairly high risk area related to the hospice benefit for Medicare. And that's because it's very concerning where beneficiaries may elect the Medicare hospice benefit, but unfortunately not do that based on sufficient information. So informed consent is a concept in the law that's unique to healthcare. And what it means is that when a patient or a beneficiary agrees to accept a service or to enter a program, they do it based on full disclosure, full information. And this is an area of risk with hospice because we have to make sure that the patient and the family, the beneficiary, understand exactly what the Medicare hospice benefit is and what it is not. So we know that hospice means palliative care, right? But do families always understand that hospice palliative care means there will be no care for the underlying medical condition that is causing the limited life expectancy, right? Do they understand there's no treatment, there's no ability, no service available to restore function? There's no effort, there's no service, there's no treatment available to cure any health condition that comes upon them in those final 6 months. And if they don't understand that and they agree to elect the Medicare hospice benefit, that is a significant compliance risk for you as a hospice. So on the other side of that coin, admitting patients to hospice who are not actually terminally ill. I mean, we all know we need the treating provider certification that the patient is eligible for hospice care. But if they truly are not, and this is just either a way to fill the hospice bed that's being pushed by the hospice provider, or this is a way perhaps for a patient or a family to obtain some sort of care when maybe when the money runs out or the ability of the family to care for a patient has reached its limit, but the person is not actually terminally ill. That is also a very significant compliance issue. Another risk area are falsified medical records or plans of care. You know, we all know that the plan of care in home health as well as hospice, the plan of care is the central sort of compliance pin. That plan of care has to be developed by an authorized provider, typically a physician. In some states, depending on the supervision or the oversight rules, that can be a PA or or an NP, but that plan of care is the whole compliance underpinning. And that if that is falsified or someone else is writing it up or someone else is signing for the doctor, that is a significant compliance problem. So you have to make sure that you're relying on plans of care that are actually developed by the treating provider and signed by the treating provider. They're dated appropriately. That's another issue. One of the other bullets there, either forging that physician signature or backdating that physician signature or plan of care. These are significant problems. These are violations, essentially. And if the plan of care is untimely or the certification comes later on after the patient has already elected that benefit, that's also a problem. So making sure it's the physician is signing, drafting that plan of care, signing that plan of care. It's dated for the date on which it actually was developed. All of that is critical. These are things that you can include in your ongoing yearly auditing and monitoring, is making sure that you're auditing those medical records, pulling samples of those medical records and auditing them to make sure that it's the doctor, the plan of care is sufficient, the plan of care is comprehensive enough to satisfy the regs, and that they're dated appropriately. So those, for this slide, I think that's all I wanted to highlight, but please do, please do look at all of our lists, because there's a lot of good information in there. And then again, on the next slide, Michael talked a little bit about referral sources. I think we've both really mentioned that. This is a real risk area in hospice in terms of gifting things to physicians and nursing homes and hospitals to sort of generate referrals to the hospice. The anti-kickback law, which I think we're going to speak a little bit, Michael's going to speak a little bit later about some updates to that, but the anti-kickback law, you should know, is a criminal law. So some of the other federal laws, like the Stark law, the civil monetary penalties law, those laws are based on financial penalties, but the anti-kickback law is a criminal law. It's a law under which the Department of Justice prosecutes people and indeed does send people to jail. So there should be no incentives at all. There should be no gift giving. There should be no professional courtesies going on. Any referrals that you are generating should be generated based on merit, and certainly relationships and familiarity in the community. Good sort of transparent marketing can be very effective and is certainly acceptable. But taking people to dinner or sending elaborate gifts at the holidays, or gifting equipment or expensive things to a physician or a hospital, absolutely a high compliance risk. We talked, I think, a little bit about overlap in services. You have to be really careful when you're providing hospice, for example, in a nursing home, that everybody's only billing for what each provider is providing. And also, you have to be careful not to make assumptions that the nursing home is going to take care of A, B, and C, and we're only going to take care of D and E. You have to be really clear, and you have to have really good open communication with the nursing home to make sure that, first of all of the services that are being promised are being delivered, and that there is no duplicate billing for the same service. That's really important. And, speaking of services in a nursing home, you also want to be careful. Our bullet says, make sure that there's a written agreement and that it's been finalized before you provide services within a nursing home. And I would really go a step further and say, anytime there is money changing hands around the delivery of service to patients, to Medicare patients or federal patients in any federal healthcare program, always make sure you have a written agreement. So that really goes beyond, I mean, that not just related to your involvement with a nursing home, but pharmacy, anywhere. Make sure you have written agreements in place where there's any collaboration or any financial exchange of money involved in providing care to a patient. You always have to be careful about not billing at a higher level of care than was necessary or than what was provided. Don't fudge the levels there ever. It's sometimes better to be more conservative and have the confidence that you can defend what you're billing for. And then, I think you're probably aware of this if you've been in hospice or home health for any period of time, but billing for inadequate or substandard care is considered a compliance violation. So a failure of quality is a failure of compliance. And so your quality of care, you should be auditing that as well. And don't just focus on correcting the quality of care. That's very, very important, obviously, but make sure that you do not bill for care that really does not meet the standard of care. And then I would go, I think, to the next slide. We have a few more items of practical advice here. So as in any healthcare area, make sure that anyone providing care is qualified and licensed. There's been some issues recently. Well, they're always out there, but there have been some issues that we've read about recently, even nurses with fake credentials, are unlicensed people providing care at a level they're not trained or credentialed for. Those are things you have to always be on guard against, particularly if you're hiring folks. Folks moved around a lot. There was a lot of travel nursing going on during the pandemic, and the healthcare community is a lot more mobile than it used to be. And we have to really be on our guard to make sure that licensing and credentialing is always in order for any folks that we're hiring. The issue again about, as Michael said, is no problem at all to amend a medical record. That is perfectly acceptable, and there's a right way and a wrong way to do that. And backdating medical records is a compliance risk. It's not only a potential violation, but if there's any kind of a pattern there at all, that can be a criminal violation. So that would be very concerning. And then, we talked about any marketing that you're doing, incentivizing financially, incentivizing your sales folks, so your marketing folks, to have goals related to length of stay in hospice, or you have to be very, very careful around your sales incentive plan if you have one, and you really need to make sure that that's vetted by legal counsel, because there's so many tripwires involved in financial incentives to folks who are doing the marketing for hospice. And then I don't know if it's on this slide, but it's on one of our slides. You want to be careful that you're not billing for hospice or billing for hours where the care is really being provided by volunteers. Sort of leaning on your volunteers for services that you're billing for or that you're expected to provide is very, very risky business. So just moving to the next slide, I would just amplify here on slide 23. We talked about this, arrangements with other providers. Be really careful that you're not billing for services that the other provider, for example, the nursing home, is providing. And the other point there we wanted to amplify, be really careful about not providing financial incentives to potential referral sources. So really take some stock in your relationships with the physicians, the nursing homes, the hospitals that you are regularly doing business with. Really evaluate what's the nature of your relationship, and are you improperly incentivizing at all the referral sources. A box of beautiful cookies or pastries around the holidays is one thing, but paying for fancy dinners. Or I heard a story just a couple days ago about a hospice sent gift certificates to a physician's office for the staff there to all get manicures. That's really not acceptable business practice, and you just really want to be careful that you're not conducting business that way. So I think we can go to slide 24. Yeah, and what I wanted to highlight here, again, the overlap is an issue. Relinquishing core services, that second bullet there, to either the nursing home itself or your volunteers or privately paid professionals, maybe the family's paying companion staff or something like that. You really have to be careful. I think I've seen plenty of this out in the field, and don't turn a blind eye if you're leaning on your volunteers, or you're leaning on the staff at the nursing home, or the family, or the family's paid professionals, high risk area, because that's the sort of thing that usually gets investigated based on complaints. And you just don't want to be on the other end of that. And so, and I think the rest of this is somewhat duplicative of what we've already talked about. So I would skip to the next slide. The marketing, you want to be really careful about improper patient solicitation. So don't impose yourself on families, particularly with elderly patients in hospitals, or being treated by your local community physicians there. It's one thing to have, really beautiful, sincere commercials online or commercials on television, making sure that your community or your target audience is aware of your services, aware of your reputation in the community, and so on. But going through charts, somehow getting access to charts, either in your local community physician group, or your assisted living, or at the hospital, that's a huge no-no. Don't do it, and be really careful around that. And then sales commissions based on length of stay, there's a number of reasons why that's problematic, not the least of which is that it might influence, if you have a marketing team, it may influence them to look for and solicit patients who might tend to have a longer length of stay, so that would result in a more significant commission. And again, unacceptable. First of all, as I said, your sales commission plan needs to be reviewed by counsel, but in addition, you really want to make sure that you are recruiting essentially on a level playing field, and you're not targeting patients who you think will be more lucrative for you. And then you really need to include marketing standards and finance standards in your training, so that your teams are aware of really what the do's and don'ts are. And you need to have a policy on it, but you should be actively training on it. And then your audit program, we talked about how you should have an ongoing auditing and monitoring program. You really do need to focus on, as I said, take a hard look at your relationships, and make sure that you have contracts in place if you have any financial arrangements with referral sources, and make sure that you are not in any way financially incentivizing your third-party referral sources. I think that's what I have for these particular risk areas. I think Michael's going to talk about some recent, the special fraud alert and some other recent guidance.
Yeah, we're going to fly at this point because I know we're getting late. There's a 1995 fraud alert that's up here. All this we've talked about a number of the various items up here. The importance, I think, is to understand that they've been around. A lot of these issues have been around since 1995 and are still around, and the OIG is still seeing violations. Can we go to the next slide, 27? This is, as all of you folks know who are in the hospice business, this has always been a particularly tricky relationship, and right now, and the topic of and requirements are now part of the are now covered by regulation. The nursing facilities, it's at 42 CFR 483.70, and for hospice, it's part of your conditions of participation at 42 CFR 418.112. You need to be familiar with these. Also, the National Hospice and Palliative Care Organization has published a guide that shows the regs and the interpretive guidelines. But among other things, obviously it needed to be in a written agreement. And as you all know who are in the hospice business, the hospice gets reimbursed for the patient by Medicare. The hospice pays the nursing facility only for room and board. And the room and basically you want to make sure that, among other things, that the hospice payment for room and board should be no more than the rate that Medicaid pays for room and board in a particular state. You also, another area that's really critical and difficult is the separation of duties. Hospice employees perform hospice duties, and nursing home employees only perform the services consistent with room and board. And that's not always an easy thing to control, because aides are used to taking care of a patient and a patient's needs, and they get attached to the patient. And they've got in the nursing home side, you've got to be careful, and on the hospice side, the same thing. Hospice can pay the facility if its staff perform certain palliative care hospice duties for the patient, but you can only pay at fair market value. The slide lists a number of problematic practices that the OIG's found troubling in the past, and these issues still remain an area of focus for the OIG. Among other things, one of the things that you want to make sure of is that you don't allow a hospice, you don't go into a nursing home, a nursing facility, or an assisted living facility and start digging and start just going through patient records to try and find people who you think can be transferred to the hospice. There has to be a referral for that. The next slides, 28 through 32, Regina, you're going to be handling, again, with a focus on the fact that we'll stay for a bit, but I know that a number of these people will have to leave. So, Regina?
Oh, yes, sorry about that. I think, actually, I think we've already talked about the offering of gifts and inducements, but we do have the quote there, or the link there for the OIG bulletins. So I think that I'll just refer you to that, to our comments that we've already made, and to the link there to the OIG guidance, and we can skip to the next slide. Same thing on the next slide. Really, these are some specifics on the OIG guidance around the gift giving and the limits on the values there. So again, you should go ahead and look at these links, and even print them out if you keep a manual, a desk manual. These would be great resources to keep in your desk manual for reference, and to even adopt your own policy around these. I think you can skip again. This is just a lot of detail. And then, Michael, am I on this slide as well? 30, sorry about that.
You're on till 33.
Okay. Okay. So, yeah, I think we talked about improper arrangements, money changing hands essentially for patient referrals, falsely certifying anything, but certainly falsely certifying homebound, medically unnecessary services. That is the medical necessity of a service is really the basis of the integrity of any claim. So you always have to make sure that you have medical necessity for any service, no matter which sector of healthcare you're involved in. Gio, if you could go to next slide.
Heidi, Heidi. I'm sorry. Yeah, Regina, oh, never mind. I'll jump in after this real quickly just to point something out.
Yeah. Again, same thing here on slide 31. We talked in general about upcoding, medical necessity, improper referral, money as the basis of improper referral. All of this, all of these are basis for criminal prosecution. So certainly top of your list to be avoided. And then you can go, Gio, to 32.
Yeah, I want to mention, if I could, one thing about physicians and home health agencies. A big issue is still the payment to medical directors, and in fact, the UPIC looks into that. One of the big issues I remember looking to representing a large healthcare hospital system down in Florida many moons ago, and I had brought on a fellow from one of the major accounting firms, and I mentioned to him, be really careful in this area as we were doing diligence on the agencies. And we found agencies all over the place with multiple medical directors with varying levels of compensation that tied into referrals. Don't. Your medical director should be paid on a fair market value. It ought to be in the contract itself. You probably want to keep time records so that you can demonstrate that the medical director is actually performing those services. It is still a very big issue, and you want to watch out for that. And I'm sorry, Regina, for interrupting on that.
No, important point, Michael. Thanks for pointing that out. And then here, there's a key concept on this particular slide. As Michael said, you have to be really careful with medical directors, really with all physicians, making sure that your payments are fair market value. The other thing I think important on this slide is there's this concept in compliance and healthcare, making sure whatever you're paying for, whoever you're paying compensation to, that comp should never vary with the value or the volume of referrals that you're getting from that relationship. So keep that in mind as a key concept. No variation in comp based on value or volume of referrals. And then, Gio, if you want to skip to 33. I think this is more the same, honestly.
This is just to mention real quickly, there's a process for going to the OIG to ask for an opinion based on that you folks are probably aware of, based on whether or not, even if the conduct might otherwise violate or be potentially contrary to the AKB and the kickback statutes, it might act. There are a number of because of the breadth of those statutes, there are a number of instances where the conduct is or the arrangement is actually valuable, and there are plenty of protections within the arrangement. There's a process where you can write to the OIG. You've got to show them specific documents of the arrangement. They will give you an advisory opinion. That advisory opinion will apply only to those specific facts and only to the entities that are part of the arrangement, but they're published and they can be valuable guidance to folks. Additional in looking at arrangements with your lawyers. Additionally, we've seen instances where companies will actually ask for an advisory opinion in order to get a negative advisory opinion, so that they don't have to reduce themselves to conduct that they know is going on out in the industry, and that otherwise puts them at a competitive disadvantage. You can go to the next slide, Gio, if you want. This one is for Regina.
Yeah, I just would urge everyone to take a look at the OIG work plan. That's a public document on the OIG's website. And this is a list. You probably want to take a good look at this in the context of your risk assessment. This is a list of the investigations that the OIG itself has on their work plan related to in-home and hospice services. So that'll be helpful to you to understand what are they looking at so you can look at it yourselves internally.
Thank you. This is a slide that just talks about certain activities that that can generate an investigation or an audit. We'll leave this to you folks to take a look at. It's here as a reference. The one thing I would mention is predictive modeling, where the government has certain bells and whistles that trigger an audit or an investigation as they're looking through claims data. And obviously, the other is that it's not really up there, but it's critical. If you get a complaint from an employee, take it seriously, investigate it. A whole host of key TAM cases, many of them come when the employee made a complaint internally and nobody took it seriously. Make sure you do your investigation. Otherwise, I would just read the rest of read these at your leisure. Since several of you are leaving, if you want a copy of the slides, if you email Gio or Regina or me, we can send them out to you. Next slide. Regina, I think, should we just skip past this one as well, since we've looked at that?
I think it speaks for itself.
Yeah. I do want to talk quickly about excluded individuals on the next several slides. I'm gonna do it in bulk just to save time. But basically, you are not allowed to use an individual who has been excluded from any of the federal healthcare any of the healthcare programs, and you're subject to a civil monetary penalty. The special advisory bulletin on the effect of exclusion from participation is extremely helpful, and there's also a new self-disclosure protocol as well. And the prohibition goes not only just to those people who deliver direct patient care, it also can go to administrative staff as well. And there's actually a mechanism and the protocol for actually quantifying for administrative expenses. You're also held responsible for having excluded contractors and for your contractors using excluded individuals. If you can go to the next, to 39, Gio, they're out of order here. This just tells you that you're subject to a civil monetary penalty. If that occurs, it also becomes an overpayment. And now if you'll go back one, these are sources that you should be checking, both the federal excluded individuals, and I apologize for moving quickly on these, but the OIG publishes what's known as the list of excluded individuals and entities on this particular website. GAO publishes them on the SAM website, and a number of states have also their own exclusion databases. You need to check for every contractor and every employee before hiring to see if they're on these databases, and on a monthly basis, and take screenshots and keep them in your records to show that you have actually checked the list every 30 days. Any of you who have go, if you would, Gio, to back to slide 38, if you would. Any of you who have 38, Gio. Any of you, I'm sorry, we've been there. My apologies. Any of you who have checked the LEIE will understand that it's an imprecise, to some degree, it's imprecise. You need to check, for example, it won't pick up the difference between hyphenated names and middle and last names. So if you don't check both, you won't pick it up. Also, you've got to check under every name that the individual might have utilized. Aliases, maiden names. I had a situation where the company actually had checked and looked at the employee's social security number, the name on the social security card. The name had a hyphen. The person was excluded in an unhyphenated version of that. Nobody picked it up. There are also, because it's a time-consuming task, there are services out there also who you can hire to do this, or you can do it in-house. Can we go to the next 40, if you would? Again, this is just a quote that tells you of your responsibility for contractors using excluded employees, and also the fact that you want to make sure that you require in your contracts, if you can with your contractor, one, an indemnity clause in this area, and two, requiring them to check the LEIE SAMs and state excluded list. The next slide, if you can. This just talks about what we talked about earlier on the timing of all of this, that you should be doing this. Also, there's a voluntary disclosure protocol. This is one of the few areas there is no way to cure the use of an excluded individual unless you go through the voluntary disclosure process. Use counsel that have done it before, know what they're doing, either internal or external counsel, or your chief compliance officer who know how to do this. There's a lot of give and take with the OIG, and you want to artfully do your voluntary disclosure. Go to 42, if you will. This is a case that I actually was involved in, and that's a staffing company used an excluded a nurse who had been excluded. They had actually checked. They had a process in place to check the LEIE, and nevertheless they missed it because they looked at the Social Security card, and I can't remember whether the card had a hyphen in the name and the employee was excluded without the hyphen or reverse. But the employee was on the excluded list. They made a voluntary disclosure because they needed to make sure not only that they protected themselves, that they cured it for themselves, but also for all of the assisted living facilities and nursing facilities where they had used the nurse as a staffing company. They didn't want their customers to be gigged, and so we resolved it for all of them. The lessons learned are check names under a variety of different spellings, maiden and married names, and do it on a monthly basis. Make sure you check the contractors. The voluntary disclosure protocol isn't inexpensive. You will usually get hit with 1.5 times the damages, the overpayment, the damages, and you might want to use an outside service. And then 43 is just, the next slide is just an example that you can read of an exclusion under a state statute. Again, be careful of your state slides. Can you go to the next slide? This is an important slide. If you get a subpoena or a search warrant, one, get counsel involved immediately. If it's a subpoena, you're probably going to be doing a rolling, what we call a rolling production, meaning counsel may be able to get an extension and almost certainly will get an extension and enable you to go through the process on a rolling basis. One of the things that you do on a subpoena is you will want to make copies of everything. You will want to be careful to go. You want to make copies. You'll want to be careful to have somebody who, before you give something out, to look at what you're giving out, because you want to make sure that you stay within the scope of the subpoena. Any of you who saw the Jones case on TV, when the attorney for Jones had accidentally handed over the cell phone, Jones's cell phone, that had a whole slew of electronic information that wasn't covered by the discovery request or search warrant or subpoena. Also, electronic discovery and disclosure is tricky. Get counsel involved early, and whatever you do, never call someone, in the example, and tell them to lie to the FBI. You've just committed obstruction of justice. Get your counsel involved right away. Next slide, if you could. The next three slides, go to the next slide, if you would. Recently, back at the end of 2020, the OIG revised its safe harbors, and CMS revised their stark exceptions to allow for and make them consistent with the need for value-based arrangements. It loosens them up a bit and makes them consistent to be able to accommodate those. We do a full presentation on this. You can find it on our website, on the Texas Association of Home Care and Hospice, back in, I believe, June of 2022. If you want to listen to that, I would go to, if you would, to slide 48. We've got some quick tips in here as well. I'll run through these quickly. Regina will run through marketing, which is really important. Educate yourself. Have a compliance plan is obvious. Next slide. Tips for best practices. The key here is physician relationships. We've been over these a number of times. Again, I'd review them. Just pay real attention to your medical director, contracts and relationships. And generally, you only want one medical director with a backup medical director for an individual agency. If you're a large company, you may alter that somewhat. Do you want to move through, if you will, to, I think, something for Regina that we haven't gone over carefully, and that's the marketing practices. I believe that starts at 51. Regina?
Yes, Michael, and our listeners. I actually do have to jump off the call. I have another call, client call waiting for me. I think I would recommend that you read through these tips and practices around your marketing staff. There are labor law issues regarding the marketing staff, as well as compliance issues that you have to be careful about. And again, making sure that you structure your compensation arrangements in a lawful manner. I think you really have to do that with advice of counsel. We have some information here around making sure that you're not calling employees independent contractors. Essentially, that's a labor law risk on top of all the other healthcare risks that we have. If you do have any questions that I can address for you following the call, please do feel free to reach out. I know we have our contact information on the last slide. And
Yeah, and Regina, I can go over a little bit of this for them if you've got to jump off.
yes, thank you.
Okay, one of the things that you want to be careful of on slide 51, Regina has been through a lot of this, but there's a safe harbor for employees. Make sure that you don't call an independent contractor an employee. If you're trying to fit into the safe harbor, make sure that they really are employees. And the OIG has been looking at this in the past, trying to challenge problematic practices for people who were deemed employees who didn't meet the IRS definition. Make sure that your compensation fits the personal services safe harbor. Look at compensation plans for marketing employees. Don't base it on number of admissions or lengths of stay, and just really be very careful of incentive payments and make sure they're not based on individual production, especially economic production. One thing we've actually seen out there, something I would not recommend doing, which is parties who have entered into marketing arrangements and want to get out of them try to sue to invalidate the contract because they believe that because the arrangement is illegal because it violates the safe harbors. You might as well just send an email to the Office of Inspector General saying, come prosecute me. But we've actually seen there are suits out there where that has occurred. Don't do it. If you have to negate a contract, sit down with your lawyer with the other side, and presumably cooler heads will prevail. The next slide, 52, I've just reviewed through there. There's some good tips and they're pretty self-explanatory. And the same thing with slide 53. I apologize for keeping you over. If you have questions, please feel free to reach out to Regina or me, and please feel free to ask us, email us and ask for a copy of the slides. Sophia?
Thank you so much to our presenters, Regina and Michael, for that information, and thank you to our attendees for joining us today. We will be sending a copy of the PowerPoint slides tomorrow, and if you have any further questions, please feel free to reach out to us. Thank you and have a great Tuesday.